Okay, welcome everybody. We are going to be talking about grievances and arbitration. The arbitration will be much more of an overview than the grievance portion of it. I think everybody's probably more familiar with grievances, more involved in the grievance process. I am Michael Coviello. I'm the Associate General Counsel of the National Fraternal Order of Police Division of Labor Services. I have P.J. Haley is with me. He is going to help with all the technical details. He will also be keeping an eye out for questions. You can type questions in, and P.J. will be bringing my attention to those questions as we go along. Some of them we will answer right away. Most of them we'll answer at the end. If we don't answer your question, you can feel free. There's an email address that you'll have at the end of the website. At the end of the webinar. You can just type in your question and we'll answer it as quickly as we can and email it back to you. So without further ado, we can move on. We already covered that information. The disclaimer. This is something that we unfortunately have to do every time we do a presentation. Everybody's laws are different. There might be some big similarities. Your jurisdiction controls how your grievance and arbitration process works, whether it be through statutes, regulations. Some of them are directly to the local labor board. Some of them are controlled by ordinances. Some of them, all of them, if they're in a collective bargaining context, are controlled specifically by the collective bargaining agreement. So what we want you to understand is that this is really an overview. We're not giving you legal advice. We're telling you how you should interpret your particular provision, whether it be in a contract or a regulation. This is just to give you an idea of how the process works and why grievances are important and how the arbitration process works, even if you don't have it in your jurisdiction at this point. So that's it for the legal stuff. Now let's move into the real stuff. What is a grievance? Whatever the parties to a collective bargaining agreement define it to be is what a grievance is. They can be very broad, meaning any disagreement between the employer and the union or an employer and the employee, or it can be very narrow. The collective bargaining agreement itself will limit the use of the collective bargaining agreement, the process that you're supposed to go through. And for those of you who are in federal employment, you know there's a laundry list of things that are excluded from the grievance process by federal regulation. So again, you have to look very carefully at what the definition of a grievance is, what is grievable and what is not. The best example I can give you is some contracts allow you to grieve a written reprimand. Other contracts specifically exclude that, saying that it's non-disciplinary. So it really just depends upon how your particular document defines what a grievance is. But ultimately, a grievance is a complaint. Someone in the bargaining unit, one of the employees, has a complaint about something management has done or failed to do, and the way to address that grievance or address that complaint is by filing a grievance. There are two basic types of grievances. There are the contract interpretation grievances, where the parties cannot agree on an interpretation of the language of the collective bargaining agreement. Generally what will happen here is the management or the employer will do something that is inconsistent with the union's understanding of the contract, and the employer's assertion will be that this is what the contract allows us to do. When the union files a grievance regarding the interpretation or a disagreement on the interpretation of the contract, the union has the burden of proof. In other words, whatever you say as the union or as the employees, what the contract is supposed to mean, you have to prove it. You're the one who's responsible for bringing the evidence to the arbitrator to say, our interpretation of the contract is X, and here's the proof that says that X is correct. I can give you a real quick example of that. We had a case in one of the departments where the interpretation of the word work was at issue. There was a provision in the contract that said anytime someone is called back to work outside their regular assigned shift will be paid overtime at time and a half for a minimum of 3 hours. The officer who filed for the overtime was actually in the department prior to the beginning of his shift. The call out went out citywide. He immediately went into the sergeant's office and started working, and it was about 15 minutes before the start of his regular shift. The employer denied the overtime. We filed a grievance saying that the term work means the verb. When you start to actually work is when you get paid. The employer took the approach that the term work meant the building, the place. So because of that, they were taking the position that since he was already in the building, he wasn't entitled to his overtime. So that is an example of the type of disagreement that you can get into with regard to the interpretation of a contract. We had to prove that the word work was a verb, not a noun. Disciplinary grievances, on the other hand, whenever an employee has been disciplined and the parties cannot agree as to the justification for the discipline, the employer has the burden of proof. In other words, the employer has to justify that the discipline was appropriate under the circumstances. And we're going to talk a lot about just cause when we get a little bit further along in the presentation. Now, the collective bargaining relationship has everything to do with what we're doing here. The collective bargaining is a source of power that gives employees leverage and equality in the employer-employee relationship. Without collective bargaining, essentially you're an at-will employee. The employer can tell you what to do, when to do it, and as long as you're there on working hours, anything the employer requires you to do that is not illegal or contrary to determined policy, then you have to do it. The differences in a collective bargaining agreement is the parties negotiate what a lot of those things will be, including hours, wages, terms and conditions of employment. It could be anything as important as what your hourly rate's going to be, all the way down to something that you might consider somewhat minor as to whether or not there's going to be 3 chairs in the break room. So basically it allows employees to do participate as much as possible in that employer-employee relationship and participate in their own working lives as much as possible from a management perspective. It is a very important relationship, and it must be maintained and wherever possible improved. This is not a relationship that can result in divorce. The only way to leave this relationship is to resign, be terminated, retire, or a far worse alternative, and for law enforcement officers, that's always a possibility. But the bottom line here is the person you work for is the person that you are in this relationship with until you no longer work for that person or that entity, that county, that city, that state. And like any other relationship, credibility is crucial to the integrity of the relationship. We all know from our own experiences that when you're in a relationship with someone, whether it's a child, whether it's a coworker, your boss, whomever it may be, your spouse, credibility or honesty is what's going to maintain that relationship, at least at a minimum level of performance. So it's important that we don't do anything to affect our credibility in the eyes of the employer, such as filing grievances inappropriately or refusing to do things that any reasonable person would acknowledge that we're supposed to do. In this way, grievances can be an effective tool to help improve the relationship between management and labor. It identifies and sets boundaries. For example, if you have a new chief or sheriff that comes into the agency and they decide that they're going to do things their way, and I'm sure nobody here has ever had that situation come up, well, grievances will eventually bring that person around to understanding that there's a relationship here that exists, it has to be followed in a certain way, and there's a contract that exists, and you have to follow that contract. You can't just come in and decide that since you're the new chief or sheriff in town that you can do whatever you want. The other thing that grievances do is they help identify and correct weaknesses in the collective bargaining agreement. The example I gave you before, even though it sounds so ridiculous, maybe we should have gone back at some point in the course of the collective bargaining agreement and defined what the term work meant. But we understood through the grievance process that 2 parties could have a different interpretation of what a particular word means. Now, I don't think anybody listening to this, and I certainly won't make the statement, would believe that the city was acting in good faith in their interpretation, but they were making that assertion. It resulted in or identified a weakness in the collective bargaining agreement, and later on down the road we had to go back in and fix that and more clearly define what the terms meant. And see, that's the thing about weaknesses in the collective bargaining agreement. You don't even know that something is a weakness or something needs to be clarified until something like that comes up sometimes. So that's what grievances enable you to do. And oftentimes you can settle a contract interpretation grievance by redefining a term or clarifying a provision in a collective bargaining agreement. But grievances can also destroy the relationship. Unwarranted or bad faith grievances or unreasonable conduct in the grievance process. In my state, Florida, one year we had 4 hurricanes crisscross the center of the state, and one agency in particular was constantly overworked as a result of it. By the time the 4th hurricane came around, when the Alpha Bravo signal went out, 3 or 4 of the officers called the union and said, "We're not going. We're just not going. We've had enough of this. Our families need us. This is not fair to us." We, as the union, could have filed a grievance, but it wouldn't have been a good faith grievance because that's the job. Yes, it's oppressive. Yes, it's been a bad year. Yes, it's unfair. Yes, all those things. But this is what you agreed to do, and we're not going to go in there and file a grievance just so you can get what you want. What you want is not consistent with the job, and it's not consistent with the contract. So if we had filed that grievance, I'm sure it would have been made very public by the employer city. It would have given the individual officers certainly bad reputations, and it certainly would have given the FOP a black eye in the state of Florida. But you know, we had to make a decision, as much as it disappointed the membership, to say, look, I'm sorry, but there is no merit to a grievance to be filed here. If you get terminated for not showing up to work under these circumstances, there's going to be very little, if anything, we can do to help you. You have to go to work. And you know, fortunately, cooler heads prevailed. Everybody went to work. Nobody got fired, and fortunately, no one got hurt. Avoiding grievances. The duty of fair representation controls everything that a union does. The duty of fair representation came from a series of cases in the United States Supreme Court in the mid-1940s that dealt with a union, railroad unions, that were refusing to represent African-American members. And as a result of those cases, which were consolidated in the United States Supreme Court, the United States Supreme Court came up with the duty of fair representation. And the duty of fair representation says that a union must represent all members of the bargaining unit without hostility or discrimination, must do so honestly, and must always act in good faith and not arbitrarily. What does that mean? What that means is, as the union, it is your responsibility to represent everybody in the collective bargaining agreement in a manner consistent with what you know the agreement to be. There have been times when I've been asked to file a grievance or to argue a case that I ethically knew was not correct because I was present at the bargaining table, or I was consulting with the bargaining team at the time the contract was negotiated, and I could not in good faith take advantage of an ambiguous term in the contract when I specifically knew what the intent of the contract was, and I was not going to allow a bargaining unit member to take advantage of what might have been some inartful wording or imprecise wording in the contract to try and take advantage of the situation. So that's what we mean by acting in good faith and being honest. When we say not acting arbitrarily, what we mean there is, if you're going to make a decision on whether or not you're going to file a grievance, it has to be made consistent with what everybody understands to be reasonable and good faith. You don't decide that just because you don't like someone in the bargaining unit that you're not going to represent them or file their grievance. You don't decide that you're not going to take a case to arbitration because it's going to be far too expensive of a case, because the law does not allow that. The law says that if there is a good faith, meritorious grievance, you must file it and you must process it. Now, in a way to avoid acting arbitrarily or in bad faith, you must fully investigate all grievances. And when I say investigate, that means that you have to talk to all the witnesses. You might have to do public records requests. You certainly have to talk to the officer. And you have to make a full determination after looking at the collective bargaining agreement and any relevant policies, statutes, regulations, etc., whether or not the officer or the employee has a legitimate complaint. If there is a legitimate complaint, the grievance must be filed, even if you believe that there is not a high likelihood of success. As long as there is some legitimacy or some merit to that grievance, it must be filed and it must be processed. Now, in doing that, you must look at the collective bargaining agreement and determine whether or not the language of the collective bargaining agreement addresses the particular situation. If the grievance has no merit, it should not be pursued, and it should be explained to the person who wants to file the grievance. Now, the collective bargaining agreement. All grievances begin and end with the collective bargaining agreement. I like to say all roads lead back to the collective bargaining agreement. Grievances and how they are processed are governed by the collective bargaining agreement and can affect the next collective bargaining agreement. That is to say that if you identify through your grievance, a grievance that you filed, that there is a problem with your collective bargaining agreement, that's going to be one of the first things you're going to look at when you start to sit down and determine what it is that you want to do in the next contract. The next contract will include a lot of things that you've learned along the way, and grievances is just one of those ways that you learn about your collective bargaining agreement. You could file a grievance that you believe has significant merit and a high likelihood of success, and the arbitrator disagrees with you. Well, that's okay, because you can still take from that to the next bargaining session, the next contract, and negotiate the things that the arbitrator found against you. We've already covered the second half of the screen in terms of changing ambiguities, missing and limited provisions. Cumbersome process. One of the things that happens in collective bargaining agreements for grievance processing is there'll be a 4, sometimes 5-step process, sometimes as little as 3 steps or 2. But you file a grievance with your immediate supervisor. Once the immediate supervisor makes the decision, it goes to the next step, which might be the deputy chief. After it goes to the deputy chief, it goes to the chief. After it goes to the chief, then it goes to the city manager. That's a pretty cumbersome process when the people below the city manager or the county administrator does not have the authority to change a decision. If you have an officer who's been terminated who wants to file a grievance because the termination was not for just cause, again, which we'll discuss in a moment, going to your immediate supervisor is a waste of time, because even though the contract gives that person the right to adjust the grievance, if the sergeant puts the terminated officer back to work, what do you think is going to happen to the sergeant? It's obviously going to be a problem. So what we try to do is we identify these processes in the contract, and we try and eliminate the unnecessary steps. What we try to say is, okay, if there's a disciplinary case, it goes directly to the chief for grievance processing and then to the city manager. If it's a termination case, it starts at the city manager's level and then goes to arbitration. So we try to narrow it down. A lot of times you will not get management to agree to that in the collective bargaining process because they want you to go through all those steps. And they want you to go through all those steps because there's a better likelihood of you missing a step if there are 3 or 4 steps, with each one with a different deadline, and therefore have your grievance waived, than if you just have 1 or 2 steps and you can just process it in 1 or 2 steps right to arbitration. So a lot of times management won't agree to do that, but ultimately down the road they may, because even they realize that it's a meaningless process if there's not a remedy available at every step. So writing a grievance. When writing a grievance, you must determine who the grievant is. Now I know that sounds like a no-brainer, but it's really not. There are times when one individual, as in a discipline case, gets disciplined. Okay, you have that one person did not deserve the discipline that was issued. We're going to file a grievance. Well, what if in the process of issuing the discipline, management skipped over 4 or 5 different policies and didn't follow its own procedure for determining whether or not the officer was actually guilty of the alleged allegation or the alleged violation? That now takes on a bigger scope. It's not just this one officer that received unfair discipline. It's the entire bargaining unit has been deprived of the appropriate due process that is required by your contract. So your grievance, even in a disciplinary case, your grievant may actually be the entire bargaining unit. There may be cases where you have a grievant who has been subject to harassment, foul language, hostile working environment in roll call, but the officer does not want to be singled out, does not want to be identified as the person complaining. Okay, that's no problem, because when a hostile work environment is created, it affects everybody in the bargaining unit. So the grievance, assuming your contract addresses this type of scenario, your grievance can be filed as a union grievance or an FOP grievance, not identifying a single officer. Now, keep in mind that if someone is a little bit timid and doesn't want to necessarily pursue it all the way to the end of this may very well be an arbitration, and someone's going to have to testify at some point. So we have to be very careful of advising our members that if we file a grievance, when we file it, at some point, you are going to be under oath telling the story of what the grievance came from. The other thing that you need to do is determine whether a loss has been suffered. In some cases, that's pretty easy to determine. If you have been disciplined, suspended for a day, you've lost a day's pay. Well, what if you've been transferred and you haven't really lost anything? All you've lost is maybe your senior status on a particular shift. You know, that you're transferred into another shift or another division. Are those things grievable? This is really going to depend upon what the law of your jurisdiction says. In some jurisdictions, if you've been transferred or even been put in a position that deprives you of overtime opportunities, which would sound like a loss, it's an economic loss. Courts have routinely held that loss of overtime opportunities, because overtime is not a guarantee, it's not part of base pay, is not considered a loss. So you have to take a very close look at whether or not a loss is actually been suffered. Because you might have a determination that you were treated unfairly, but if there was no actual loss suffered, all an arbitrator can do in terms of the remedy is to say, don't do that again. You must follow the collective bargaining agreement. Identifying the article of the collective bargaining agreement at issue. Now, clearly, if you have a management's rights section that says management has the right to issue discipline up to and including termination for just cause, anytime there's a disciplinary case, you're going to argue that management's rights provision. It violated the just cause provision of management's rights. But there are other things that might apply. And the story I like to tell is a case I was personally involved in where an officer was terminated for a whole host of things. There were 3 officers that were initially accused of this incident. The only one who was investigated was the FOP member that we represented. The city that this officer works in is approximately 85% African American. The city management is almost entirely African American, including the city manager. The 3 officers that were involved in the case were, one of them was African American and 2 of them were white. Our FOP member, who was the one who was terminated, was the African American. When we got down to the brass tacks of writing the grievance, I was flipping through the contract and I found discrimination provision. Discrimination provisions are sometimes in your contract, and most people feel like it's a nice, good thing to put in the contract. Well, in this case, it worked in our favor. We weren't filing a discrimination case against the city, but we included the discrimination article that was violated in our contract. And I got some pushback from our own staff. They said, no, we don't need to do that. The city manager is black. Most of the city management is black. The officer is black. It's the city manager's decision, so this is not racial discrimination. And I said, look, you're not naming the city manager as the person who violated the contract. It's the city that violated the contract. Anytime someone in an official capacity takes action, they are the city. Just like whenever one of you out on the street does something, you are the police. Well, when somebody in the city administration does something, that is the city doing it. So we filed it, and I was the only one who felt strongly about it. Everyone felt strongly against it. They gave in to me. We filed it, and that was the one thing that the city manager, who I knew personally, was most upset about. He called me screaming and yelling, how can you say this? How can you say that I, as a black man, have discriminated against other black men? That's outrageous. And I said, Reggie, hold on. The city accused 3 officers of doing something wrong. The only one who was investigated, the only one who was disciplined, the only one who was put in this position was black. The other two white were not even investigated. And he took a deep breath, and 3 days later, our member, the FOP member, was put back to work. So you just never know how strong a particular argument may be. Even if you think it only slightly applies, put any article of the CBA that could possibly help you argue your case in there, as long as you're doing so in good faith. You must interview the grievant. I can't tell you how many times I've looked over a grievance and I've asked the person writing the grievance, what is the grievance position on this? What did the person who has the complaint say? Oh, well, we just went off the contract. Okay, well, how about we get the whole story from the person who's going to be the one testifying when we get to the arbitration page that gets that far. Now, I will say this. You have to beware of privilege issues. There is no such thing as a labor representative, labor member privilege anywhere in the country, with the exception of maybe Ohio, Hawaii, and New York. Or, New York. And those are not very strong. What this means is, in the event that you have an interview with the grievant, there is a possibility that someone could ask you what was said in that conversation. And you do not have the legal protection of calling it a privilege, like an attorney-client privilege. However, if something like that happens, my strong suggestion is to go seek out your labor attorney and have them file an unfair labor practice for interfering with the administration of the union. There is no way that a labor representative can do an effective job administering the contract as the union and be fearful of having, every time someone wants to consult with them about filing a grievance, have that conversation revealed to management. That would, in my estimation, would be the same thing as interfering with the administration of the union. So there are some remedies, but you must be very, very careful whenever someone starts talking to you, especially if they're going to make a confession. You don't want to be around for that. That's when you call the labor attorney and have them talk to that person. Okay, writing the grievance. I've been doing this for a lot of years, and I still use forms and checklists. The reason I use forms and checklists is because if you use a form and you use a checklist, it's almost impossible to forget something. Under these forms and checklists, it helps you identify the grievant. You are directed to find the collective bargaining articles. You can identify the loss by going down the form, because the form will show you, what has the officer lost. You actually have that in the form. Write down what the officer lost. It should be right in the box. Identify the remedy. What are you looking for? It's very important. A lot of people file grievances and they don't put what they're looking for. In a disciplinary case, you want the discipline rescinded, for example. We're going to go over that in a little bit more detail. We do have forms and checklists available. If you send us an email, if you're interested, we can send you a blank grievance form, as well as a very, very long checklist that will help you get any case ready for arbitration, starting from the moment the grievant walks in your office. When it comes to writing the grievance, too much is better than too little, because you can always take things out of a grievance, but you can't add to something after it's been filed in most cases. And just remember this, if it is not in the collective bargaining agreement, it cannot be grieved. If your collective bargaining agreement simply says any violation of this agreement, then that's all you've got. If it includes policies, procedures, state law, regulation, then you can put those things in as a grievance as well. But the collective bargaining agreement will control it. If it's not in the collective bargaining agreement, it's not a grievance. And more importantly, or as important, is if it is not in the grievance, it cannot be arbitrated. Just like a civil lawsuit, if you file count 1, count 2, count 3, and you leave out count 4, and it suddenly occurs to you that, oh, I needed count 4, there was another argument I could have made for a recovery, if it's not in the grievance, the arbitrator will not hear it. Grievance format. Here is I give you an idea of a very short form of what a grievance would be, but as you can see, it includes all the things that you need. It's got the name of the employee, their classification. This could be police officer 1, police officer 2, corporal, sergeant, etc. The immediate supervisor's name, the date of the grievance. This is very important, the date that you file the grievance, because that will determine whether or not you've met the deadlines under the contract. A statement of the grievance. Now look, this doesn't look all that technical. Article 1 and Article 2 The city terminated Officer Mayberry without just cause. The city did not follow the termination article in the collective bargaining agreement. There's nothing all that detailed about that. If it involves something that the city went out of their way and did wrong, you might want to detail what was actually done wrong, and specifically by whom. That's fine. Like I said before, too much is better than too little. But here we were talking about the remedy. When you do when a grievance is remedied, we call it an adjustment. The adjustment that the union requires in this case is to have Officer Mayberry reinstated with full back pay and benefits, and this is the key phrase here, folks, as if he were never terminated. The reason why you want that phrase in there is because you want to make sure that you rewind the clock back to the day before the officer got disciplined, so that all of the terms and conditions of that employee's job and employment and all their benefits get reinstated as of that point. The reason why you want to make sure of that is until the law really takes effect and pre-existing conditions are no longer permitted to be used for disqualification, if you or someone in your insurance program or your insurance plan has a pre-existing condition, you get reinstated, they have a pre-existing condition. This is brand new insurance as far as your insurance company is concerned. So you may have an exclusion or a disqualification based upon something that wouldn't have existed if the discipline had never occurred. So you want to make sure that everything gets reinstated. To have the city remove any and all references to this matter from his file, that is going to be controlled by public records law. If your public records law allow for the expungement of things from public records files, disciplinary files, then you certainly want to include that in there. Especially important for people who are going to move from agency to agency throughout their career, not to have something following them that's not supported. To mandate that the city follow the termination article of the CBA in all future cases. And then here comes another one of these really strong phrases that you want to make sure you use. To otherwise make Officer Mayberry whole. In other words, if there's anything out there that we can't think of that the arbitrator needs to do to put everything back the way it was, to rewind the clock all the way back, then we want you to do it, and this is the phrase that enables you to do it. And then such other and further relief necessary. It's a little bit redundant, but you know what? It can't hurt you. It would hurt you if you didn't have it in there. It can't hurt you for having it redundantly in there. Now, presenting the grievance. Follow the collective bargaining agreement requirements to the letter. All deadlines and time limits must be met. Now, if someone comes into your office 3 days before the deadline expires, don't wait 3 days to file the grievance. Get it filed as quickly as you can to make sure that nobody can challenge the calculation of time as to when it was filed. Remember, a grievance cannot be filed after the deadline for filing. If you have 10 days to file a grievance, make sure it's filed on day 8. If it can't be, excuse me, you cannot advance to the next step after the time limit. If your first step says filed within 10 days with the immediate supervisor, 10 days after the immediate supervisor receives it, the immediate supervisor will reply, and then you have 5 days to move it to the chief's office. If you don't hear anything in 10 days, the 5-day clock has started, whether they've gotten back to you or not. A lot of people forget this. If their response was due 10 days from now and you haven't heard anything, you now have 5 days to just walk that thing across the hall to the chief's office. Don't wait. If you don't do it within those 5 days, it's over. You cannot advance it after the time limit expires. Remember we said that the cities and the employers like to keep those cumbersome processes in place, and this is why. The other thing you need to be concerned about is whether you're talking about calendar days or working days. And you need to make sure. This is an ambiguity that exists in most contracts. At the very beginning or at the very end of every contract, there should be some miscellaneous section that defines, either a definition section at the beginning or a miscellaneous section at the end that defines various terms. In this contract, any reference to days, unless otherwise specifically stated in the paragraph in which it's contained, shall mean working days. Very simple. Once you do that, everybody knows what it is. The other thing is for calculating, what's day one? That ends up being an ambiguity. If I get disciplined today, is today day one, or does day one start tomorrow? Again, very simple. You define that. Any time a calculation of days is required by this contract, day one of that calculation shall be 24 hours after the event that triggered the calculation of days. Now it's very simple. If it happened on Monday at noon, day one starts Tuesday at noon. The other thing you need to be careful about is with these time limits, if the discipline was issued at 4 o'clock on Monday and I have to file this grievance on Friday, do I have to file it by 4 o'clock? Do I have to file it by 5? Is it midnight? Very easy. It's usually the end of business. Most arbitrators would say that. But what you need to do is make sure your contract is clear, and you can say by 5 p.m., 5 days after the date of the discipline, or the date of the calculation began. And remember, folks, grievances cannot be amended without mutual consent. So if management won't let you amend it, if you haven't put it in there, it's too late. And you must be consistent at each step. You must make sure that the arguments that you're making from step to step to step are consistent with each other. That doesn't mean that you can't adjust the argument for things that you've learned along the way, but you should be arguing the same general theme throughout the processing of the grievance. PJ, does that mean you have a question?
Yes, I have two questions coming up. One was a question from Rodney in Washington, and he is asking about whether the grievance clock starts for an instance of overtime. Does the clock start once the request for pay was made and denied, or does, sorry, it moved a little bit, does the clock begin once the paycheck is received?
Okay, that's a good question. The general rule is that grievances, the clock starts at the time the employee knew or should have known that there was something to grieve. If the grievance request slip is returned and it states that it's denied, that would be the date that starts day one. If you wait until you get your check, it may be too late. It might be day one of a 14-day pay period, and you have 10 days to file a grievance. You're going to be out of the ballpark. So I would make sure that any time, the first instance, that you have any knowledge that you are not going to get something that you think you're entitled to, that's day one. It's when you knew or should have known.
The second question is, what if the city manager delays past the response time?
If the city manager delays past the response time, that's the same thing as your, when I said before, if the response is due on a particular date, they don't respond, then as far as we're concerned, that still continues to go. That clock still continues to run. So if their response is due on day 10, and you have 5 days from day 10 or from any response to move it, you treat day 10 as that's the response date. You move it to arbitration. That's the next step. You go, especially if there's a deadline or time limit that between the response and the next action. No response is considered a response on the last day declining the grievance or rejecting the grievance. That's the way you have to think of it.
And an additional follow-up, going back to the overtime question, what if the individual cashes the check? Is that tantamount to an agreement?
No. No, this is not, paychecks are not like when you sign a check for work performed or a debt owed and somebody accepts it without a notation on the check. No, you're entitled to cash your paycheck. If your paycheck is short, you're still entitled to your grievance if you cashed it. Absolutely. Now, I will caution you, check the laws in your jurisdiction, but I'm not aware that that would be the case anywhere in the country.
That's all we have at the moment on the question side, Mike.
Okay, settling the grievance. Can you be flexible? Now, especially if you're dealing with a situation where you're talking about an interpretation of the grievance, you might not get the interpretation you want, but can you be flexible in terms of going forward from this date on? We might not get what we want out of this grievance today, but at least we're going to have contract language we can live with tomorrow. That might be something you'd be willing to do. You have to always keep in mind, if you settle the grievance, that's you in control of the case. If you put it in the hands of an arbitrator, you're not always sure how it's going to come out. It could come out in your favor. It could come out partially in your favor. It could come out 100% against you. So you have to consider how flexible can you be. What am I really trying to get from this grievance? If I have an officer who was terminated, who really did something kind of stupid, that wasn't necessarily termination, and they're willing to come back and say, okay, we'll make it a 10-day suspension and put them back to work, can you be flexible enough to accept that under the circumstances? You have to consider the likelihood of success and whether or not it's reasonable under the circumstances to resolve it in a way that makes not everybody completely happy, but at least preserves the collective bargaining relationship as well as the contract. Grievances can be settled in whole or in part in any step. So, for example, you got this termination case. You get to the chief's office, and the chief says, you know what, termination was a little harsh. I'm willing to make it a 180-day suspension. You accept the 180-day suspension. The officer goes back to work. You are now taking the 180-day suspension forward. Okay, the grievance continues to the next step because you can accept the reinstatement, but 180 days is still unreasonable, so we're going forward. Now, if management says take 180 days and we're done, then you have to decide whether or not that's an appropriate remedy. Are you still willing to go forward, knowing that the officer is going to potentially remain terminated? Is 180 days a good deal under those circumstances? But just know that you can just because you accept a partial settlement, or what we would call in that case a partial adjustment, you would keep going forward on the part that is still contrary to what you think should have been the result. Does the grievant need to give you permission? No, because remember, this is the union's contract, not the employee. The individual employee does not own the contract, the union does. However, the grievant must be consulted. It would be a very, very big mistake to settle somebody's grievance without even talking to them. Now, the question of when should you settle depends on what the duty of fair representation requires. If the duty of fair representation requires that you only advance good faith grievances, if you settle a termination case for a 10-day suspension and there's no merit to the argument that the officer shouldn't have at least been suspended for 10 days, then you no longer have a meritorious grievance and you should settle. Arbitration. Arbitration is the last step in the process. It's when all of the other negotiations and attempts to resolve it have failed. And so the question I would ask if we were all in a room together for answers is, when does arbitration begin? I'll cut to the chase and I'll tell you. Arbitration begins the moment the grievant walks into your office. You start preparing that grievance and that case and that argument before management as if you were going to arbitration tomorrow. Everything that you would do to get a good case ready, you do it from the moment the grievant walks into your office. Now, we're going to talk about just cause. Just cause has 7 tests, and this comes from an old arbitration case from the 20s. Now, when I say 7 tests, that does not mean that all 7 tests have to work out in one party's favor or another. Some of the tests are so significant that just failing on one of them will end up resulting in the union winning the grievance, but this is essentially due process. The vast majority of these things going in one direction or the other will basically determine the outcome of the case. So, for example, reasonable rules and orders, notice, investigation, fairness of the investigation, proof, equal treatment, and fairness of the penalty. I'm going to go through those individually. Reasonable rules and orders. Is there a specific policy that the officer is accused of violating? Can the agency consistently explain its own rules and policies? Are the policies consistent? Has there been training? Real quick, had an agency that had one part of the policy that described exactly how pursuits were supposed to take place, what you could and couldn't do, and a completely different part of the policy that said all pursuits were prohibited. And they both existed in the same version of the same policies. They also trained officers under the existence of both policies on exactly how to do a pursuit. They took them out to a decommissioned Air Force base and actually practiced doing pursuits. An officer got disciplined for conducting a pursuit because the policy was prohibited pursuits. So that ended up being a winning case for us because obviously their rules and orders were not consistent and they trained people to act a certain way. You'll see here it says Rodney King in parentheses. What this means is the Rodney King cops who were acquitted in the first time they went to state court, they were acquitted because the training officer stood up and said, everything they did exactly what we trained them to do under the circumstances. Maybe we have a bad policy, maybe we need to change the way we do things, but the officers did exactly what we taught them to do. This is not the same thing as when they were just following orders. If you're going to arbitrate a case like this, You want to look at training records. Who was trained? How were they trained? Were they good at it once they were trained, et cetera? All of that stuff will work in your favor in terms of the training aspect with regard to how someone acts under a policy. Notice, have the officers been issued policies and procedures? Everybody gets a big book when they sign up first day, sign here. And that's what they sign. They look at it, it says, I have read and understood the attached policies. They won't give you the book unless you sign for it. There's no way you could read the policies. It doesn't matter. If an arbitrator sees you signed an acknowledgement form about the policies, you're going to be held responsible. Now, is the specific policy at issue in writing? Is there a standard that everybody's held to, or does it change? That's what we're looking at here. If the specific policy is not really, it's kind of everybody knows it, but it's not really written, it's kind of our unwritten policy, everybody knows and understands it, well, you can't really enforce that kind of policy. That's a bad notice is what we would call that. Is the policy clear and unambiguous? Obviously, in the case of the pursuit, you had contradictory policies. If the policy is contradictory, it is not clear, and it is absolutely ambiguous. Has the policy been recently changed? If there's been a change in policy or a change in discipline with regard to certain disciplinary or certain actions, that change has to be put in writing, and everyone has to be notified of it. That's the idea of notice. If you're not notified of it, you can't be expected to follow it. That's what we're talking about. With a policy, specify penalties for categories of violations. If they tell you that if you do X, you can be disciplined up to and including a suspension, and they terminate you for it, that's a problem. They can't violate their own policies. And I know a bunch of you are sitting there thinking, oh, really, not in my department. Well, I got news for you. If you fight those things, you win them more often than not because they're not supposed to violate their own policies. And I know chiefs always say, well, those are just a guideline. Yeah, it's a guideline for the chief, and it's the Bible for you. If you violate it, you get in serious trouble. If the chief violates it, well, he wrote them, and that's just the guide for the chief. Well, you can fight those things. Was there an investigation? This is big. I've had a few cases where there was no investigation. An allegation came in, they took one statement, bam, discipline. Well, that's not what we would call an investigation, especially if in every other case they do a much different or much more thorough investigation. You're allowed to compare what they did to you to what they've done in other cases. If in every other case they do an extensive investigation, they have to do an intensive and extensive investigation on your case too. The other big one is, were statements and evidence preserved? Oh, I spoke to so-and-so and she told me that the officer did this. Really? Well, where's the statement? You didn't tape it, you didn't record it, you didn't have a stenographer there. What, are you kidding me? I don't believe that's what the person said. I've actually had this come up. Witness said X, Y, Z. Really? Call witness, and they say, not only did they not speak to me, I've never even heard of that officer. So you got to make sure that they preserve the witness and the testimony of the witnesses and other evidence. Was the investigation fair? Did the investigator explore all the facts or just the facts that made the officer look bad? Were all potential witnesses questioned? When you go in and you give your internal affairs statement and you know there are witnesses out there that will support your position, you don't hold those in your vest like you got a pocket full of aces, because that will not help you defeat management in the fairness of the investigation claim. You give them the name of those witnesses that will support your position, and if they refuse to investigate by talking to those people or taking their statements, then you have the claim that they did an unfair investigation, and you can prove it because here are 4 witnesses that I identified to them. I gave them their names, addresses, and contact phone numbers. They never talked to them. Had they talked to these people, the investigation would have come out differently. They did an unfair investigation. Arbitrators hate it when that happens. They hate it when employers do that. Did the investigation reveal evidence of the alleged violation? Here's a good one. You did the investigation. Did it show that I did anything wrong? That's now, if you have one witness saying A and another witness saying the opposite of A, what does that prove? It proves that 2 different people told 2 different stories about exactly what happened. Who are you supposed to believe and trust? Well, it doesn't really prove much of anything unless they can show that one of those people was lying. Was there evidence of mitigation or justification? In those particular cases, what you want to say is this. If we have a policy that says you will not box anyone in or do a rolling roadblock, well, if the pursuit is about to enter into a highly populated area where people have come out onto the streets to observe the pursuit, and the driver is really being reckless and showing an absolute disregard for life, you probably want to box that that car in before they get into he goes driving into that crowd of people. Does it violate the policy? Yes, but can you justify it? Can you mitigate it? Yes, because we had no choice. Yes, it violated the policy, but it was a choice between violating that policy or letting this idiot hurt or kill somebody. Okay, equal treatment. If guilty, were other officers punished in the same way as other officers also guilty of the same offense for an offense of the same degree? This is where we win most of our cases. You can't treat Officer A different than you treated Officers B through Z on the exact same thing. But you have to be careful. Are they truly similar or equal? That meaning the officers. Do they have similar employment histories? Do they have similar disciplinary histories? Have they been model employees? Have they been troubled employees? Different employees can be treated differently than other employees if they are not the same type of employee. If you're a problem officer who routinely makes the same mistakes over and over again, you're not going to be treated the same as someone who only screws up occasionally doing the same thing. Has there been a disciplinary policy change? Yes, I'm being treated differently, but 2 weeks ago the policy changed and I went and did what I wasn't supposed to do, and now I'm going to be punished more harshly than anyone else because we were all notified that the policy has changed and this is exactly what happened. And this happened after the policy had changed. Fairness of the penalty. Does the punishment fit the offense? Does backing my patrol car into a light pole, chipping the paint, require that I be terminated? Probably not, unless you've done it 12 or 13 times. Has mitigation or justification been taken into effect? Yes, we did a rolling roadblock, but this guy might have killed somebody, half a mile down the road if he hadn't done it. Has employee history been taken into consideration? Like I just said, if you've been a routine screw-up, chances are the penalty for that particular incident will be more harsh and sustained as being more harsh than if it's someone who's only been in trouble occasionally or not at all. Do you have consistent evaluations? Are you someone who's steadily improving, someone who's steadily getting worse, or are you fairly consistent down the line? These are things that will be taken into consideration by fairness of the penalty by an arbitrator. Was the agency harmed or disrupted? If you do something that's so colossally stupid in the public eye, like that happened in Arizona, you go out and you have three-way sex with your wife and your girlfriend and put it on the internet, and by the way, we know it's you because the plaque that we gave you from the department or from the city is on the wall behind the bed. And this is an actual case that happened in Arizona. And we can clearly identify that, well, we know that's your wife, even though you're wearing a mask, but you see the tattoo on your shoulder and we see the plaque behind the bed, yeah, we know it's you. We don't have to prove in those circumstances that that type of conduct made in the public eye would tend to harm the agency or disrupt the agency if the general public were made aware of it. So they don't always have to prove it. However, in a run-of-the-mill case, like an insubordination case or a conduct unbecoming case, if they're going to assert that the agency has been harmed or morale has been disrupted or the public's image of the police department has been affected, they generally have to put on that kind of evidence, unless what you've done, like I said, is so colossally bad or stupid, in which case it's presumed. Certain impact on the agency can be presumed. Was the discipline progressive? And under what I call a blind progression, some agencies will say, I gave you a written reprimand for coming in late a year ago. 6 months ago, I suspended you for backing a patrol car into a light pole. Now that you've shown up with your shoes all scuffed up, I have no choice but to terminate you because I've done the written reprimand, I've done the suspension. The only thing left on the ladder is termination. That's generally frowned upon. Progression of similar offenses and penalties is required. If you back your patrol car into a light pole once a month, sooner or later they're going to terminate you for it. But they have to start with a progression. Now, it is also important in a progressive discipline to find out if corrective measures were taken. Arbitrators go by the rule of thumb that all discipline must be part punitive, part corrective. If all they're doing is punishing you but not taking measures to improve your performance or to prevent you from making the same mistakes, they cannot continue to discipline you without trying to improve your performance. And then was there some other bias? Oftentimes, union officers, because of their aggressive relationship with the administration, may find themselves on a steeper end of the discipline curve than others. And we can generally show that pretty easily just looking at records. So that's how we do that. Now, discovery. There is no mandatory discovery in arbitration unless the collective bargaining agreement requires it. If you're negotiating a collective bargaining agreement that has an arbitration provision in it, you want to negotiate a provision that says all the parties will freely exchange all evidence that is intended to be used before the arbitrator. It's very important. You want to make sure that you know everything that they know, and you don't care if they know everything you know, because if they knew what you knew, they would put the guy back to work. If the arbitrator finds out that they knew what you knew and they didn't put the guy back to work, arbitrators might actually rule in your favor and say, how could you know all this stuff and not have reversed your decision? All grievance personnel files were ever kept, including quote-unquote private files or pencil files, whatever the ghost files, whatever they may call them. You want to request that on a public records request. Witnesses files. If you have witness officers that are going to come testify, and they're going to testify on behalf of management specifically, you want their disciplinary history, because if you can show that they've gotten a better shake from management than your guy, when you go into the arbitration, you can show that this person is only testifying for management because he owes them one. He's their buddy. You want to make sure you have duty logs, dispatch dates, transcripts, previous arbitration awards, anything that you can think of. Now, if you request a transcript, I guarantee you if you also get the tape that the transcript was made from, you will see dramatic differences between what was actually reported and what was transcribed. It's not done on purpose. They have 100 of these things to do. They get kind of lazy. You might see inaudible, inaudible, inaudible written in 15 different places on a transcript. You listen to the tape, and it's really not that inaudible. So you want to make sure for every transcript you have a tape to go with it if possible. This last one, subpoena duces tecum, that's all arbitration statutes that I'm aware of allow an arbitrator to issue subpoenas. If your public records request is not being timely returned, you contact your arbitrator and you say, I need you to issue a subpoena, duces tecum for these records, and the arbitrators will do it. I've never seen an arbitrator refuse to do it in 15 years. Finding an arbitrator. Does the collective bargaining agreement require that you use the Federal Mediation and Conciliation Service, FMCS, or the American Arbitration Association? Do you have permanent panels set up in your jurisdiction? Do you have to go to your labor board, or otherwise known as PERC or PERB, Public Employees Relations Commission or Public Employees Relations Board? You have to follow the rules of the jurisdiction. You have to follow the contract. Sometimes you can select one in spite of all this by mutual agreement. If both parties say, hey, let's use Mr. Hoffman, well, then you can do that, and he can be your arbitrator. Alternate striking. You get a panel. One side goes first. Sometimes it's a flip of a coin to decide who goes first. Each party strikes someone from the list until you get to the last name on the list. Then you notify FMCS or AAA that you've got from their list. You've got an arbitrator. You're good to go. If you get a list from these places and you don't like anyone that's on the list, it is your right to reject the list and ask for another one. You may be charged an additional fee for the second list, and you may have to pay for it, but it's worth it sometimes because some of these lists might be entirely employer-friendly arbitrators, and you don't want that. How do you know if someone's an employer-friendly arbitrator? Well, you can research the arbitrators. They all have bios online. You can find some of them on Westlaw or the Bureau of, I forget what B&A stands for. Just blanking on it. But this is one of the public databases. You can, in fact, most arbitrators who publish, their opinions are published on a B&A library, and you can search those libraries with one or two terms. I found a great arbitrator. One of my officers was terminated for using the C word. We typed in the C word in the search term, and I got 5 opinions that came up with the C word, and I picked the arbitrator who published all those cases because in every case he returned the officer to work. LRIS, Will Aitchison's Labor Relations Information System. You can contact them for advice on your arbitrator list. Public employment on the web at lrp.com. They also have arbitrators they have a rating system as well as graphical data on the awards that they've issued. They give percentages. 50% of the time this arbitrator rules for management, 50% they rule for a union, but in disciplinary cases it's 70% management, 30% union. So that stuff's all very helpful. And of course you can use Google or Yahoo or even get on our FOP.net labor forum, and you can just Pick up the phone and call people is another way. Just ask, is anybody familiar with these arbitrators? You'll be surprised how much information you can get. So you're going to review their resumes, any previous positions and associations they've had. If your arbitrator has spent his or her entire career as the labor administrator for General Motors, that means they've spent their entire life representing management on labor management matters. Might not be someone who's very union friendly. Read all of their prior decisions, or as many of their recent ones as you can, and determine if there's a decisional trend. Are they consistently ruling against the union? Have they started in the beginning of their career ruling against the union and now they're ruling in favor of the union? You can actually see these trends as they develop. Have they reversed a trend? If they started ruling in favor of one side or the other and suddenly gone the other way in the last several? You're really looking for some stability. You want to see that they're intellectually honest, that they're not looking for a reason to sustain the discipline in the discipline case, for example. You know, you can tell when you read something. It's very obvious that they're doing everything they can to arrange the facts the way they see fit. What is the arbitrator's fee? They all charge by the day. They're very expensive now. You can expect a minimum $1,000 a day, plus travel costs. You might have a payment provision in your collective bargaining agreement that says the winner pays all, or sorry, the loser pays all, winner pays nothing, etc. And one of the things you want to do once you've selected your arbitrator is you be the one to write the arbitrator the letter apprising them or making them aware of their selection for your arbitrator, and you put it on FOP letterhead. The parties are pleased to announce that you have been selected as our arbitrator. Here's the contact number for the union. Here's the contact number for the city, blah, blah, blah. We look forward to setting up a date and working with you. Preparing the case. We're going to go through this very quickly because most of you will not be handling the arbitrations, but you may be assisting in the preparation. You got to prepare the case. If you're not prepared, it doesn't matter how good your case is, you could seriously lose. You have to research all of the requested records that you receive. It's one thing to request them when they show up in 15 file boxes. You got to look through them all. You're going to find gold in that stuff, but it's useless to you if you don't go through and look for it. Talk to everyone and find documentation to support what you're being told. If someone tells you, oh, you know, 3 years ago, all 5 officers did the same thing and none of them got in trouble, do a records request for those 5 officers' files. You need to find out. I do very general records requests. I want them, in the last 5 years, all officers who have been alleged to have committed conduct unbecoming and see their disciplinary files on those cases. You'd be surprised what you get. You get a lot of stuff, and it's all very good most of the time. You develop a theory of the case. It might be very simple, but hey, you suspended this guy for not for just cause because you treated him differently than anybody else. That's a good enough theory. You don't have to get all that elaborate. Don't be afraid to approach management's witnesses, but ask them questions. Don't tell them what your case is about. Ask them what they know. Ask them what they're going to testify about. Ask them who they've talked to on management's side, whether or not they're going to actually come and testify at the arbitration. If they are, what do they intend to say? They don't have to talk to you, but they might, and it's better to approach them and have them not talk to you than not approach them at all. You'd be surprised at how willing people are to talk to you, especially if you're representing someone who's pretty popular. You want to meet with the opposing party and see if you can stipulate to anything. You might want to stipulate to your exhibits, your witness lists, whatever the issue is, but be very careful. If you do not have a trusting relationship with management, you might not be able to get to these stipulations, and all you're going to do is tip your hand to the argument. So you don't want to tell them what your argument is, but you want to get them to stipulate to what your evidence is. The arbitrators are going to let it in anyway. Now, demeanor. I know that a lot of these times you're dealing with people that you really don't like, but you must maintain the high road. You must maintain a positive demeanor. Let management get down in the mud puddle. That's not what we do. The rules of evidence that loosely, if they apply at all, are relevance, hearsay, authentication, best evidence, and chain of custody. Generally speaking, arbitrators let everything in, and their intention is to consider everything and sort out what they want to use and what they don't want to use. But when you're talking about hearsay or relevance, those are the two strongest. You want to say, look, you might be going on and on talking about all this stuff, but it's not really relevant to whether the officer practiced patrol car into a light bulb. It doesn't matter that he's living with his girlfriend and they're not married, or she's living with her boyfriend and they're not married. It doesn't matter. Stick to what's relevant. Hearsay. If you're telling me what somebody told you that somebody else told them, that's not really very good evidence. Let's stick to what you personally know. That's how you want to approach it. Don't have someone come in to testify to what somebody else told them. You want to bring the original person in, or at least have a sworn statement. State the issue, state what the evidence will show, and what your remedy is, just like in the grievance. This is, the officer was terminated for not just cause. The evidence will show they did a very bad investigation. They didn't interview all the witnesses, and because we'll bring in those witnesses, they'll tell you that this is all nonsense, and what we want you to do is reinstate the officer, make them whole as though he were never terminated or dismissed. Very simple. There's really not a lot of magic to this stuff, folks. But don't forget the remedy. Don't forget the remedy. I've read at least one arbitrator's opinion that said the union put on a great case, but they didn't ask me to do anything, so I'm left with saying that management violated the contract, but I have no remedy, and it's too late after that. There will be a direct examination. That'll be the who, what, when, where, why questions, and then most witnesses will be cross-examined, which is where lawyers try and get you to admit stuff that you don't want to. Well, yes, you testified on direct that you were present. Well, isn't it true you didn't get there until 15 minutes after the shots were fired? That's an idea or an example of a cross-examination type question. Now, I'm going to skip closing argument and written brief for a second. Always concede that which you should concede. If you know something that you're arguing is wrong, you're going to come out like a liar. If there's a point on the table that you need to concede because it's absolutely true and correct, in other words, something you should stipulate to, then you should do it. You should never not concede something that is so obvious that you should concede, because you will look like you're untruthful. When you concede is a matter of strategy. That you must concede is a matter of rule. You must concede that which you should concede, and then you have to determine when is the appropriate time to do it. Okay, we're not going to go into these. We just kind of more or less talked about that. Understand this. It is not the witness's job to win the case. It is the witness's job to answer all questions truthfully, period. I can't stand witnesses that come in and want to give this great dissertation about everything they know and why they're so wonderful and this is why you should win the case. They will kill you. Okay, closing argument or written brief. A closing argument is done right away when the case is fresh in your mind. Once done, you are finished, and there's nothing to do but wait for the decision. There's very little time for reflection analysis. A written brief is done over time, usually 30 days. After the transcript comes in, it will take weeks to prepare because you'll go through that transcript and you can pull out all kinds of great stuff out of that transcript. I love to review a transcript. I find stuff in there that I didn't even realize was there that I can use for my benefit. And it gives you plenty of time to prepare good arguments. On top of which, I've had just about every arbitrator I've ever worked with say, when I leave the room, I'm swayed one way, I read the briefs, and I'm swayed another way, then I read the reply briefs, and I'm swayed back, and so you want to be able to make sure that you have the arbitrator's attention when they're ready to make the decision. If you do a closing argument, they're going to get up and leave. You won't see, they will not consider this case for a couple of weeks. You won't see a decision for up to a month or more. So better to have that document in front of them, that brief, that they can remind them of what your points were on a particular issue. And that's exactly why I like to brief. I not only get to reflect on the case and refine my argument over time, I can use verbatim quotes from witnesses, and I can be there as a constant reminder to the arbitrator as to what my ruling was. And what I'll do is I'll send the brief either by email or send it along a disc with the mailed copy. And I had a number of times I've seen arbitrators lift entire sections of my word-for-word brief. They just cut and paste it and put it in their award. You want to be in a position to be able to do that. Remember, there are always three cases. There's the case you prepare, the case you present, and the case you remember. That's why I say when I go back and look at the transcript, there are things in the transcript that I completely forgot happened. And nothing goes during the hearing 100% the way you thought it would when you start to prepare. So that's why it's always good to have a chance to look back and write the brief. And again, don't forget the remedy. Prepare alternative remedies. If the case has gone such a way that you realize that the arbitrator is not going to give you a full reinstatement, instead of asking for a full reinstatement, you can say, or at least a reasonable suspension that's consistent with what the agency has done in other cases. You're not going to hit the grand slam in every case. In fact, some cases you will get a reinstatement with no back pay. You'll get a reinstatement less 10 days of the appropriate suspension time. Just be prepared to argue the alternatives. The arbitrator's decisions are called awards. There are binding awards and non-binding or advisory awards. That depends upon the rule of your state, whatever your state law says. If there's something in the award that is ambiguous or incomplete, the arbitrator can clarify things that were not yet addressed. but they are not required to clarify something that makes no sense to you. It's called functus officio, which is the Latin for their office is performed. Once they submit the award, they are done. They no longer have jurisdiction except for a mistake or to open an unresolved issue or question. There were 3 counts. They only addressed 3 disciplinary counts. They only addressed 2 of them. They have to go back and address the 3rd one. Unless, of course, they sustain a termination, in which case it doesn't matter. The ambiguity issue, again, it has to be significantly ambiguous. The enforcement, if management is refusing to reinstate the officer after the arbitrator has said so, you file a lawsuit against the city, filing for an injunctive relief, an injunction to force the city to put the officer back to work consistent with the award, only if it's binding. If it's non-binding or advisory, the city can take it and say, okay, got the arbitrator's award, we're refusing to follow it. Then why would you do it? You do it because it helps clear the officer's name for future employment down the road. The employer refused to accept it, but the arbitrator, after hearing all the evidence, said the city was wrong. Appeals, very rare. There are a few cases where you'll see that have been highly publicized where an arbitrator has put somebody back to work. A city filed an appeal saying that it was contrary to the best interest of the public. For example, an officer who lied was fired for lying. The arbitrator found that, in fact, the officer lied but said it was a small lie, or this is a relatively young officer who can be rehabilitated. Once you lie as a police officer, a prosecutor can refuse your cases. If that's the case, you're no longer fit to be an officer, and we're seeing those appeals on a public policy basis coming back in favor of employers. Even though the arbitrator has the right to decide how they want, if in making their decision they found facts that clearly make you unfit for duty, the remedy can actually be overturned. Okay, now here, this is the last-minute summary. Always keep the grievant informed and involved. This is a partnership. You are in partnership with the grievant throughout the case. Get a court reporter and a transcript. Make sure that you have a record of what happened at the hearing. Who pays for it? If you order it, you pay for it. If management wants a copy of it, they have to split the cost of the court reporter, and they definitely have to pay for their own copy of the transcript. Arrive on time. Never keep an arbitrator waiting. Disclose witness problems up front. You know, I have 3 witnesses. The witness I would call on day 2 has to leave. I need to take them out of order. They're going on vacation. Just be up front with it. The arbitrators are fine with it. It's not a problem. Always be gracious to the other side, especially in front of the arbitrator. Don't get down into the mud puddle and start a name-calling argument with them. If you have exhibits that really prove your point, blow them up. Make them as big as you can. I had one lawyer I used to work with who would blow up the exhibits and actually paste them to the wall during the arbitration so they were up there and you couldn't avoid them. If you need an extension of time, you have to ask for it. If someone asks you for an extension of time in terms of getting a brief in, or if the arbitrator says, I know this thing is due in 30 days, can I have an extension? Give it to them. Give it to them. It will only make you look better. Besides, if you refuse to give the other side an extension of time and the arbitrator is contacted and say, look, the other side won't agree, but I need another month, the arbitrator is going to remember that. They're going to give them the extra month anyway. Pay all the bills on time. Don't keep your court reporter or your arbitrator waiting for payments. Now, if you're going to file grievances, you're going to be a union rep, you're going to participate in arbitrations. I love this book from Vince Lombardi. I firmly believe that any person's finest hour, the greatest fulfillment of all that he or she holds dear, is the moment when he or she has worked his or her heart out in a good cause and lie exhausted on the field of battle victorious. You won't win every case, but if you do everything that you're supposed to do, you follow the duty of fair representation, you aggressively represent your members, you will be victorious, win or lose, because you have done the right thing. That's all we have today. Here's the contact information. I'll leave it up there, and if there are any questions, now's the time.
Okay, Mike, to start, apparently there has been a change in Maryland regarding the granting of labor reps confidentiality. I'm not sure of the details of it, but we have a document that I'll forward to you at the end of this so you can review it.
Okay, I'd be happy to review it, but I can't give you any advice under it. Whatever your local lawyers in Maryland are telling you is the law under that, then follow what they tell you, but I'd be happy to take a look at it.
Okay. I'm going to jump around a little bit, but I'm going to start with, if there is nothing in writing dictating the limits of a grievance, does past practices then set the limits?
Most likely. most likely. If you don't have any limitation on your grievances, that works two ways. That might give you extra time, but it gives management time to drag it out too. I would suggest that you get into your next contract negotiations and set forth a really good process. And as PJ can tell you, on our information system, we have thousands of contracts. You can look at the language and choose what you think works best for you. But I think past practice would prevail. If they suddenly decided to start doing it differently, you probably have a grievance on that would be sustained.
Next question. If there is no likelihood of success, then will the employee look to other avenues if we tell them it's not a winnable issue?
Sure. Well, first of all, an employee can always bring their own grievance. They don't need the union. They're not required to use the union to file a grievance. Oftentimes, they'll go off on their own and they'll file it, and more likely than not, they will not be successful. If you make a determination that there's no likelihood of success, they go out and hire a lawyer and they actually win the case, you might be on the hook for their attorney's fees unless you can show you made a good faith determination by looking at everything and you have a documented process. It wasn't just a vote of the membership. By the way, if you're deciding grievances, whether grievances go forward by a vote of the membership, I can tell you you're in trouble already. A group of people who know what they're doing, whether it's a committee or your executive board, looks at it and they make a determination following a very specific process that you've laid out to determine whether or not the grievance has merit. Unless you can show that you've done all that in good faith, you may end up being on the hook for the attorney's fees for that employee who went forward and won. But by the way, the opposite is also true. If you go through that entire process and you make a decision and you are wrong and the individual employee wins, the court will say there was no violation of duty of representation. You just made a mistake. You did everything in good faith. No harm, no foul. Most likely that will happen.
Next question is, can you list a named grievant and then list generic or John Doe's when you know there are other grievants yet to be identified?
I would say, rather than list John Doe's, I would say I would just file it as a union grievance, an FOP grievance, and just leave it at that. Or you might want to list an employee and then put buy-in through the FOP as well as all other bargaining union members similarly situated or something like that. Or name the grievant, the individual grievant, as a representative of a group of employees and the FOP, and do it that way. But yeah, I wouldn't get into naming Jane Doe's or those yet to be identified, because that's a technicality for class action lawsuits that is beyond the technical requirements for a grievance. I would just say the FOP. If I really had to just choose one, I would say the FOP is the grievance.
And this one is kind of specific, and we may need to address later. It is, I'm going to read it. There's two parts to it. Can you be punished for doing too much overtime even after they were ordered to do so? Second part, currently
no,
in my...
the answer to that is no. Let me just cut you off there.
Okay.
There's no such thing as too much overtime. As long as management has assigned it or knows that you're doing it, they can't later on tell you, no, we're not paying you or we're punishing you for working overtime. Especially, according to the question, they assigned it or they knew it was happening. So
Okay.
the answer to that one's no.
Let me get down a little bit. Okay, here's another one. The administration is constantly amending the department's general orders. Should we grieve them as they are presented, or is there language that can prohibit them from enacting policies that should be bargained?
Yeah, it's called unfair labor practice. If they're making changes to terms and conditions of employment that are mandatory subjects of bargaining, like your hours, your wages, your shifts, or anything that's in the contract that's covered by the contract, that is an unfair labor practice. You file it with your labor board. In some cases, in some states, they're called prohibited practices. They cannot do those things unilaterally without negotiating at least the impact. They may have to negotiate the policy, but at a minimum, they'll have to negotiate the impact of the policy. So if they're going to change shifts and it's going to impact people who have commitments that will be affected, like daycare or education, whatever it is, they have to make accommodations for that impact. But yes, there is a remedy. You may have a grievance. If in fact, for federal officers, it's a grievance in most cases. And for most non-federal employees, it's unfair labor practice.
Next question is an officer eligible to sit for a promotional exam after a termination while the termination is on appeal?
Probably not. Probably not. That's going to depend upon, again, what your contract says. If and this is tough for arbitrators, but the remedy section that you're asking for in your grievance would be that they be reinstated, including for all promotional opportunities. That's one where that would be covered by make the officer whole. You would have to put evidence on during the arbitration that, or during the court case, that this officer would have sat for that and had a, whatever probability of success and would have been on the promotion list. There's a lot of variables that might, maybe they can't fashion a remedy, but you certainly have to put it into the request or into the grievance that their opportunity for advancement has been damaged. So that's the best I can answer that.
All right, now this question I'm going to paraphrase a bit because it was kind of asked in conjunction with what was being said at the time. In regards to like time limits and such, and please re-ask the question to the person who asked it and start, is does the same principles apply to a department that has meet and confer?
Depends on the meet and confer ordinance. If your meet and confer ordinance requires an arbitration for discipline or requires that a disciplinary process be negotiated, then yeah, it does. I've seen meet and confer ordinances that exclude disciplinary issues from the meet and confer process. So I have to refer you back to what your local ordinance is. If you have a meet and confer process that results in an agreement that doesn't exclude discipline, then yeah, go in there and negotiate for that, negotiate for arbitration. Listen, if you don't ask for it, you're certainly not going to get it. That doesn't mean if you ask for it, you will, but you definitely won't if you don't.
Next question is, does the agency actually have to be discredited by the conduct, or can the agency say the conduct was considered likely to bring discredit upon the agency?
And there again, that depends on how outrageous the conduct is. If you're engaging in pornographic activity in public view, they don't have to prove that the agency was hurt by that. That's a given that there's in all likelihood that if people realize that this is what our police officers were doing, we would be the laughing stock and not very respected in our community. But other things, if they're going to make a claim that productivity has declined, that's something they'd have to prove. But again, the more outrageous the conduct, the less they have to prove. Some conduct just stands on its own as tending to have a likelihood of causing discredit or disrepute.
What remedy does the union have when an arbitrator has failed to render their decision or award in the timeline approved by, they use the acronym AAA, followed by a secondary question, do we have an appeal or file a complaint with the AAA?
Very, very tough situation. If it's been an extraordinary amount of time, you might want to send a request to AAA, because I know they have case administrators to ask if they could follow up with the arbitrator to see what the outcome is. But I certainly wouldn't be filing complaints or appeals or trying to seek a remedy. If we're talking years, maybe your arbitrator died. I don't know. And that's happened. But there's really very little you can do that won't potentially have a negative impact on you. I would just very carefully contact AAA and ask them if they could find out what the status of the case is and leave it at that and not send it in as a complaint. Yeah, I don't think you want to upset your arbitrator.
Here's one that's unique. If an employee failed to file in a reasonable time due to a medical issue, can the time or date be changed?
If the employee failed to file?
That if the employee failed to file in a reasonable time is the language of the question due to a medical issue. What
would end up happening in this is what's known as an arbitrability question. You file the grievance, it will be rejected as being untimely. You take it to the next step and say it, and they will continue to say it's untimely through every one of those steps. But you have to make the argument that it was a physical impossibility for this grievance to be filed timely, and you have evidence of that. An arbitrator might consider it. The arbitrator might look to your contract to say there is no provision for a medical excuse or what have you. It's a question that has no specific answer, because it would all depend upon the arbitrator you selected, depends upon the language of your contract. When you get into negotiating the contract, even if you were going to try and put in an excuse provision or a grace period provision in there, you'd have to define the circumstances under which it would apply. That would lead to litigation. But if you're already in that situation, I would go ahead and file it. Make the argument that it was done as soon as reasonably possible after the physical disability was relieved. You know, if the officer was on military leave, for example, or what, you know, you just have to make the argument. You just have to put as much evidence together as to why it was impossible to file on time and hope the arbitrator rules in your favor. In the meantime, you continue to make the case that you would had it been filed on time. You just add the give us a break argument on top of everything else.
Okay. Next question is kind of a languagey one. If you name the specific violation of the contract, can you or should you add something like and any other section of the contract that may apply?
You could, but I don't know of too many arbitrators that would take it upon themselves to go through the entire contract or to allow you to just throw the kitchen sink. I understand what you're trying to say with the catch-all provision. I would actually spell out any article I thought came even close, as opposed to just saying and any and all other articles that may apply. I mean, you may want to put it in there as a matter of practice, but I'd be interested to see if an arbitrator would actually latch onto that for you.
And then we have a fun question. We have members.
Like fun questions.
Yeah, we have members we have members of the bargaining unit that are not FOP members and therefore not in the FOP LDP. We know we must file and process the grievance, but is the union obligated to pay the costs of arbitration and or attorney fees for that grievant? Can we require the grievant to pay the costs?
Great question. Arbitration is exclusively, in most cases, is exclusively the remedy of the union. It's the union's tool. However, some jurisdictions, Florida being one of them, requires the union to specifically spell out that is the exclusive remedy of the union. If it doesn't specifically spell that out, then anybody can go to arbitration. Now, you may not be required to provide an attorney because that would be your legal defense plan. All you have to do is represent them. So you could send the staff rep or the labor rep down to the arbitration to represent them. There's nothing that requires you to pay for an attorney, even for your own members, unless you set that legal defense plan up for your members. Nothing requires that under the duty of fair representation. There are employee representatives all over the country, the post office being one of them. The postal unions don't use lawyers. The Postal Service doesn't use lawyers. That is strictly employees that are non-lawyers that handle those cases. At least that's the way it was several years ago. So you don't have to give them a lawyer. You may have to give them representation, unless the jurisdiction law says you don't have to, or unless your contract says that you don't have to.
Next question is, what if the union does not want to pursue a grievance citing merit, but the city has done everything wrong from failure to respond in a timely manner and provide evidence of or to substantiate a denial to a grievance?
Then the grievance has merit. That grievance, absolutely, if the city fails to follow the procedure, especially a procedure that's agreed upon in the collective bargaining agreement, the grievance has merit and the grievance must be filed.
And I believe we have a question.
And by the way, the remedy on that would be that the city is admonished to follow the contract procedure from now on, or in any future case. I'm done.
It takes care of most of the questions. There is an individual requesting to use a microphone. And
oh boy. Is it Rodney in Washington?
It is not Rodney in Washington. It is Mark's. Oh, apparently he is not requesting to ask a question now. He just re-asked a question, say not now.
Okay. All right. I hope that means we answered the question.
So I believe that is everything. If anybody has any questions, please send them to labor@fop.net, and we'll try to get them. Mike, I'll pass it back to you.
Thank you, everyone, for your time. I do realize that we went a little bit longer than I had hoped, but I hope that wasn't a problem for anyone. If you have any questions, I look forward to hearing from you. And some of you I know, I looked at the list. Thanks for joining. Thank you all for joining. Those of you who I know, I hope I get to see you all soon. Everybody have a good afternoon, and thanks for your attention.